Good morning, ma'am. Are you Michelle LaChasse? And this is cause number 22-39304. Ms. LaChasse is on probation for abandoning or endangering a child. It's a state jail felony. And that probation was for a 3-year deferred probation, October 17th of 2022. Has that been extended? Okay. So obviously, we'll see what we do today, but if there's going to be safety, I think that would be a requirement for me to do that. So I received an administrative hearing on April 30th from Mr. Ruiz with some issues that have been going on with regard to Ms. LaChasse allegedly going to the Sky Bar Lounge, failing to adhere to the curfew, failing to adhere to mental health services and treatment plans, remaining compliant with medication, admitting to drinking, and also admitting to trying to locate drugs as well. That hearing recommendation was to continue supervision and request SafeP, which was agreed at the time by Ms. LaChasse. I signed off on that and ordered it. Mr. Nix has filed a motion asking that I reconsider that. I have asked probation for kind of an update in their response to that, as well as the state, who said pretty much it's up to me and probation and everything else. So it's my understanding, Mr. Nix, that Ms. LaChasse is wanting to do some kind of local inpatient treatment.
So Your Honor, if I could briefly just kind of give a little bit of a recap. She had her medication switched on March 11th and March the 20th. And shortly after that, if I can present this, I've shown a copy to the district attorney's office this morning. It showed that they made a major medication change, took her off Seroquel, put her on Prozac. She immediately started having issues with the Prozac. She's still having issues with the Prozac. She's taking the Prozac at the jail. They're giving it to her. She's having issues. What we've done is we've spoke to Baptist hospitals. I have her mother and I have her fiance here. We have documentation that she would be accepted into inpatient at Baptist Hospital. Also have a letter from her doctor.
But that's just a 5 to 7 days.
No, they can actually keep her inpatient for up to 30 days, Judge, and then they have an outpatient program that could continue after that. If I could present this is a letter from her doctor that kind of underlines her very exacerbated issues. What I'm asking the court to do is not to exactly undo the SafeP. What I'm asking the court to do is hold the SafeP in abeyance, give her a chance to do the inpatient Baptist, make sure that she's on the right medication. I presume that a major medication change is about to take place due to the fact that she's having such issues with the Prozac, and we reconvene after she's completed an inpatient stay. Whether it be 14 days, whether it be 30 days, I'm assuming it'll be 30 days based on what the fiance's talked to with Baptist. It would come at no cost to the taxpayer or to probation. We've already cleared it with her insurance. She's stayed there before, and insurance covered almost 100%. I'm asking the court to just hold the SafeP in abeyance until she can do the inpatient treatment. We reconvene in 30 days and see how she did in the inpatient treatment. And then depending on how the reports go, how everything that I turn over from her inpatient stay to both probation, the state, and the court, you decide if SafeP is still in her actual best interest at this point. We understand that SafeP is also a blessing. She could have been sentenced to state jail time. We're not underscoring the issues. We're explaining to the court that this is a mental health issue caused by a major medication change that's documented. Her issues follow immediately after this. And she's still on the Prozac, and she's still having lots of problems in the jail on the Prozac. We're asking that we just hold this in abeyance. I'm not asking the court to undo it, take it away, put her back on regular probation. I'm not asking for that. I'm asking to hold it in abeyance, place her, allow her to be placed in the inpatient.
But we don't, do we know, is it up to the hospital how long she stays?
I believe so, Your
I can't
Honor.
order some
Correct.
certain amount of
Correct.
time.
And however long that is, if the court feels that it's not long enough, we can reconvene and I can show you the records at that point and we can make a decision from there. But Baptist has told the family that it would be up to 30 days and then they have an outpatient treatment that can continue after that. Now, of course, we won't know if that's appropriate until we see how she does in there, but it's pretty clear that this is a medication change that caused this behavior.
Mr. Nichols?
Judge, part of the main hesitation on our part is that she agreed to SafeP and now wants to do things on her terms. I think SafeP is where she needs to be based on the relapse and the violations she had. And I want to bring to the court's attention, when she was first put on probation in 2022, she was ordered ISF. Didn't want to go, went to a private inpatient program in Harris County, which she was discharged unsuccessfully from. So it's almost like we're rewinding the same script as before, and it obviously didn't work then.
I didn't see that.
I don't think it's contained in the admin. I think Mr. Ruiz can testify to that, though, Your Honor, if you want more detail. He informed me about that this morning.
Okay. Do you have any disagreement with regard to what happened at the beginning of probation that they're talking about, Mr. Nix?
I'm not sure that I was a part
You were
of that, so I don't know that I can speak to that. What I can speak to is that they made a major medication change that immediately caused these issues. SafeP is a wonderful program that's helped a lot of people. I don't know that it's fine-tuned for her mental health issues that are causing the issues right now. I think it's a fantastic program, and I still think she might end up there, but I think if we get her the right mental health treatment and get her on the right medication, she's much more likely to be successful in SafeP if she has the right medication and she is of the right frame of mind.
The special needs SafeP facility, do they adjust medications and things like that? Yeah. I think based on what I know now from the beginning that I ordered or agreed or whatever happened with ISF, and then agreed to allow her not to do what everybody else thought was appropriate, go to her own choice, unsuccessfully discharged from that, and here we are having the same problem. So I'm not going to adjust that order.
Yes, ma'am.
I am going to order the special needs. It's special needs safety. It's not the regular one. It is, the whole purpose of it is to treat both things. And so that can all take place there, and I think that would be better for her and for our community. In addition, I am going to, because of the issues in the administrative hearing, the fact that a motion hasn't been filed, the length of time, I think, obviously is an issue. And so I am going to also at this time order that Ms. LaChasse's probation be extended by 2 years. That should give plenty of time to get through the program, get through aftercare, make sure everything is going like it should be, and then hopefully get off this probation without a conviction or going to state jail. All right, I know it's not what you want. I hope you take advantage of it. However, it's a good program. You can talk to them about medications and get stabilized before you get out and get on aftercare. Okay, thank you, Mr.
Thank you,
Nix.
Judge.
Thank you, Mr. Ruiz, for being here as well. Good morning, ma'am. Are you Ebony Broussard?
Yes, ma'am.
And Ms. Broussard is on probation in cause numbers 19-32518, 19-32806, and 21-36615 for the offenses of escape while arrested, assault on a peace officer, and possession of a controlled substance. There's been motion to revokes filed in all three of those cases. And Mr. Nix, what is the announcement?
Your Honor, I've spoken with the state. I think we have something in the works. I think we'd both like a 2-week reset. And I think in 2 weeks, some offers that we made to the state to try to resolve these issues will be made whole at that time. And I think this will be worked out at the 2-week reset.
Any issue, Ms. Malfino?
Judge, I have spoken at length with Ms. Johnson, who has worked with this defendant for a long time now. Of course, respect her position ultimately in that she is the one who actually works with her. There are quite a bit of arrears due in this case. Ms. Broussard has been ordered previously to pay those with forms of income such as her tax return, etc. She has been defiant in doing that to the probation department. Mr. Nix indicates that she, via her family while she remains in custody, is able to do that in the next 2 weeks, and I'd like to reconvene at that time to maybe see where we are. Our position in the alternative would probably be ISF cognitive. In fact, if she does not get that paid, we may just go ahead and proceed with the motion. We'll be ready to do it on that day.
Okay, sounds good. Thank you for being here, Ms. Johnson. We'll reset the case for 2 weeks.
Thank you, Judge.
Thank you. Oh, no, no one asked.
Okay, I'm just making sure.
Was that one, the one that just left? Okay. Good morning. Are you Terry Rose?
Yes, ma'am.
And Mr. Rose, in cause number 241369, is charged with the offense of murder. There was a request for a competency evaluation that was done by Dr. Grapon. I'm going to take judicial notice of the court's file. We have received that evaluation dated May 23rd of 2025. Dr. Grapon, after that evaluation, makes the finding that Mr. Rose is currently competent to stand trial. Is there any other evidence with regard to competency? Mr. Burbank?
Defense, Judge. No, Your Honor.
Then at this time, I am going to find that Mr. Rose is competent to stand trial. Mr. Burbank, announcement?
Your Honor, as you are well aware, I'm the second one.
Right.
I just need one more announcement, 30 days or 40 days, and we may be able to.
Okay. Any issue with that, Mr. Nichols?
No, Your Honor, we're just, state's ready to proceed.
And I appreciate you getting up to speed as quickly as possible. Looks like we've got an investigator involved and you've taken care of that.
We
So
do, and I was out, I provided him information, and he's helping me with this, and so once I cover all my bases and get up to see the district attorney, we'll be able to take care of this now.
all right, what I'll do to make sure your investigator, you have plenty of time to get up to speed, is reset it 45 days and expect an announcement on that date.
Thank you. Your Honor.
All right,
Maybe
thank you.
excuse to that time.
Yes, sir.
Thank you, Judge.
They print out the ones that are being, just the 4 that he's pleading on. I need,
Got these right here, if that's what you need.
everything, all of them except 0534. Good morning. Are you Bryce Thomas? And Mr. Burbank, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor. We're going open on each case, and the aggravated sexual assault is being the lesser included indecency by exposure, which is a third degree.
So is,
Did you sign it? Did not.
we can do it. Y'all can get it done as soon as I'm finished. I'll go
Completely about the registration.
I'll go through it with them. I just want to make sure, because of the agreement for the lesser in that case and for anything to run concurrently, is that the plea bargain agreement where he would be waiving his right to appeal?
And also, they're
dismissal.
dismissing the UUMB.
Gotcha, okay. Give me just a second, yeah.
And the lesser included is instead of a first, is a
Third. Oh, 0354's been dismissed, I think. Or 0534, whatever I said. Okay, Mr. Thomas, in cause number 24, DCCR 0389, you're charged with a third-degree felony offense of possession of a prohibited weapon from January 31st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In cause number 240390, you're charged with a third-degree felony offense of possession of a prohibited weapon from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In cause number 24 DCCR 0391, you're charged with a state jail felony offense of theft of a firearm, and that's from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? And then what is the reduction to?
It's indecency exposure for a degree felony.
In cause number 24, DCCR 0392, the state has elected to proceed on the lesser included offense of a third-degree felony of indecency with a child by exposure. And that's from November 9th of 2023. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? Do you fully understand them? And I want to make sure you understand there's kind of a partial agreement, and that agreement is that the state is going to dismiss cause number 240534, which is an unauthorized use of a vehicle. They are agreeing to that lesser included offense of the indecency in that case. And they're also agreeing that if anything that I sentence you to, if it's time in prison, would run concurrently. There's not a specific agreement with regard to any time or any outcome, only those agreements with regard to the dismissal of the case, the reduction in the other case, and the fact that they'll all run at the same time. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, in that indecency case, do you understand that you will be required to register as a sex offender? And Mr. Burbank will go over that more with you today, and there's a document you need to sign today with regard to that. And do you understand that as well? State tenders number 1 in each case.
No objection, states 1 in each case, Your Honor.
It's admitted in each case. Is there any evidence that Mr. Thomas is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each of your cases to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done. That'll give me more information about you, your cases, and we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Burbank. He will present it to me on your behalf when we come back. All right? You can go back with the bailiff.
May be excused to that.
Yes, sir.
Thanks for watching. Make sure to hit that like and subscribe button for more crazy court hearings like this one.